Hi, I'm Emily, and I am here with Maya Murphy's attorney, Eva Marie Franco Fox. Attorney Fox practices at Maya Murphy's office in Westport, Connecticut, and is admitted to practice law in both Connecticut and New York. My question today for Attorney Fox is, can my Connecticut prenuptial agreement include provisions that deviate from state law?
In Connecticut, parties to a prenuptial agreement or even a postnuptial agreement can include provisions that either align with what the law would dictate, for example, in the event of one of their deaths or in the event of divorce, or they can include provisions that would deviate from what the law would dictate. So, for example, in Connecticut, spouses generally have the right to inherit from one another. So, they can include one another in their wills, they can inherit under those wills, or in the absence of a will, if one spouse passes away without any estate plan, the other spouse can still inherit. In fact, even if you've explicitly disinherited your spouse in your will, they still have the right under certain circumstances to elect in or inherit up to a certain amount of your estate anyway, even if it wasn't your intention. So Connecticut really acknowledges the right of spouses to be able to inherit from one another. So your prenuptial or postnuptial agreement can include provisions that essentially affirm this right and say, yes, the parties are going to inherit from one another. Alternatively, the agreement can be silent on the issue and leave it to the state law to default at the time of the divorce or the death of one of the parties. Alternatively, in this estate waiver of estate example, the parties can deviate from the law. They can include what's called a waiver of estates rights, which essentially has each party waive their right to elect or invoke their elective share right, meaning if they've been disinherited, they agree they're not going to contest that. They agree that they're okay with being disinherited. Doesn't mean they have to disinherit one another, but they're not going to contest it if they are disinherited. Now, I want to draw a distinction here. Deviating from the law does not mean that you can include provisions that would violate the law. So, for example, this deviation, including a waiver of estates rights, is very different than including a provision that would contemplate violating a state statute. The parties cannot include provisions that would violate the law or violate public policy. They can't include provisions that would be considered unconscionable or morally reprehensible. So, for instance, the parties have the right to waive alimony, but if the waiver is going to render one of the parties reliant on public assistance, the court can review that and say, well, we're not going to enforce that provision because it violates public policy. We think it's unconscionable if one party is rendered destitute as a result of this waiver. So again, the agreements can really deviate, but they cannot violate the law or violate any kind of public policy. Now, most people enter into these agreements specifically because they intend to deviate from what the law would otherwise dictate. Often, these parties who enter into these agreements are saying to themselves, what the law would dictate isn't appropriate for our situation. It's not how we would want our assets or our income or our debts treated in the event of one of our deaths or in the event of our divorce. So we want to circumvent those laws and really come up with a customized plan that fits our needs and addresses our concerns in a more appropriate way. And that's okay. The law will consider that enforceable, again, as long as it's not violating any law or public policy. So it's important for you to consult with an attorney, A, to find out what the default laws are in order to better assess if you need to deviate from them, and to address your concerns and address your needs with your attorney so that your attorney can assess whether or not these other options are appropriate for you.
Attorney Fox is available 24/7 and can be reached by calling 203-221-3100. You can also email Attorney Fox at efox@mayalaw.com, and please visit mayalaw.com for more information.